Copyright Act 1957. These are some of the important sections. फर्स्ट ये चीज बता दूं कि कॉपीराइट का जितने भी लिटिगेशंस होते हैं यूजुअली दे गो टू आइदर कमर्शियल कोर्ट और दे विल गो टू civil judge court or high court. Now, the factor that determines where to go is based on the pecuniary jurisdiction. If the amount is more than 10 lakh, then usually it will go to high court. Now, coming back to the important sections, first is section 13. Section 13 talks about the areas where Copyright Act is applicable. In simple language, Copyright Act is uh, enabling statute which helps one to protect one's creativity. अगर आप IPR को देखें तो IPR है to protect innovation, copyright है creativity. जैसे you write a book, you compose a music or write a lyric, or maybe a design, creative design that has commercial application, any sound recording, those sort of things come within the purview of Copyright Act. Second important section is the section 22, which talks about the term, which is usually 60 years. What does it mean? It basically means once the author has died, post death, for 60 years, the copyright claim exists. So even if the author has died, maybe his or her legal representatives or legal heirs, they can come and file a suit if somebody has maybe stole the author's work. So after 60 years, when the author has died, after 60 years, anybody can uh, take the author's work and they can do whatever they want. The copyright doesn't exist anymore. Section 30 talks about the licenses. A license is basically, in simple language, it's taking permission from the author or from the owner, whoever owns it. Uh, Let me show you one present litigation. So this is Sony Music, which has filed a civil litigation, civil petition before Mumbai High Court against Myntra, which is a shopping brand, over copyright infringement claims. And why they have done it? Because they have used Sony's music, their recordings, in their various advertisement without taking license from the owner. And it is valued 5 crores. That's why you can see it is before Mumbai High Court. Next is when copyright infringed. As you saw, if you do not take permission, if you do not have approval, necessary consent, it could be oral, it could be written. If you do not have either, then you have violated Copyright Act. You have infringed the author's right. Section then litigation, attracts. Section 52 talks about a few areas where Copyright Act doesn't apply, which are mainly scholarly area or academic area. So if let's say I'm a scholar and I'm using your work for some scholarly work, in that case, the author cannot go ahead and file any kind of suit against me. If I use it for commercial purpose or for any revenue generation purpose, then again copyright violation happens. Section 55 talks about civil remedies. Usually, you don't have much of penal action, like no as such jail that usually happens. Provisions are there, but usually most of these litigations end up claiming monetary damage. As you saw in Sony case, they are asking 5 crore. 65A section is a recent addition amendment. This brings whole new areas of Copyright Act. This includes the various areas of technical design, computer software, and electronic goods or gadgets. Design is also a very important part, so you need to go through Design Act separately to better understand how. Because there, these three acts: Copyright Act, Design Act, and then your intellectual property right. There are overlapping areas, so whenever you are reading, better you read all through all these three one by one, so that you understand where they conflict, where they coincide, and the overlapping areas. Better understand and navigate through these statutes. Thank you.